Breakdown, Glenn, it looks like this federal judge just completely lost her patience with the Trump administration in court. Can you explain what just happened?
Brian, she lost her patience for good reason. The DOJ lawyers that Trump is sending into court and arguing these Venezuelan immigration deportation cases are making a mockery of the Constitution. A lawyer actually said to this judge, Judge Charlotte Sweeney, that, well, Your Honor, we intend to honor the due process rights of these people we are going to deport by giving them just 24 hours notice before we stuff them on planes and send them to a prison in El Salvador. The judge was basically shocked. She said, no, I am ruling that the Trump administration must give these folks that they are intending to deport at least 21 days advance notice. Why? So they can understand their rights to be heard, so they can acquire counsel, so they can be prepared to go into court and present a case if they choose to do so, that they are not subject to deportation because, for example, maybe the Trump administration mistook a soccer tattoo for a gang tattoo. So this is the first time, Brian, in all of the litigation that we've been seeing in several different federal jurisdictions and then up to the Supreme Court and back down again. This is the first time a judge has set a time frame to make sure the Trump administration is complying with the constitutional guarantee of due process, notice, and opportunity to be heard, because the Trump administration was playing games with the Constitution, saying, we'll give them 24 hours to put up or shut up, and then we're going to send them out of the country. And a judge finally said, no, you're going to give them at least 21 days advance notice.
And so, Glenn, does this ruling apply solely to the plaintiff in this case, or is this a more all-encompassing ruling where any migrant who the Trump administration is seeking to deport has 21 days notice?
Yeah, Brian, that's a great question. Technically speaking, this will only apply in that case in that federal court in Colorado. It's a court that sits in Denver. So it will have atmospheric implications because now other federal judges will say, well, there has been a benchmark set by another federal court taking up this identical issue. So I have a feeling most federal court judges will probably adopt that 21-day advance notice requirement, but they're not obligated to. All of this stuff is going to ultimately bubble up to the Supreme Court. And I suspect the Supreme Court will allow for some flexibility in how much advance notice is required in each case. But it feels like this 21 days is probably an important benchmark that has been set.
Glenn, don't we have to wait for an appeals court ruling to actually establish some degree of precedent? Like, we'll have conflicting rulings from different federal courts in their respective federal circuits, but really we have to wait for one of these rulings to be handed down by an appeals court so that it actually becomes precedent. Is that correct?
Yeah, that's true. So trial court judges don't set precedent. They only rule on issues in their case, and that becomes binding on the parties in that case. But it also becomes atmospherically important and relevant to other trial court judges in that federal circuit and nationwide. Other judges will look because most federal judges are interested in uniformity of the application of these kinds of rules kind of across all of the federal circuits, but they're not required to abide by what one of their fellow judges in a different federal circuit rules. But the thing is, the 21-day advance notice determination by Judge Sweeney out in Colorado is not the kind of thing that the Supreme Court will weigh in on, I predict. They don't say, well, you know what, under the circumstances of this case, we're going to say 20 days is enough, or we're going to require 22 days. Notice an opportunity to be heard is a flexible concept, and it depends on a lot of different things. What the government is trying to do to somebody may dictate exactly what kind of notice and what kind of opportunity to be heard they're entitled to. Because one thing that I would point out, Donald Trump posted something, I think in response to this, saying, oh, there's no way we can hold hundreds of thousands of trials for hundreds of thousands of immigrants we want to deport. He said, quote, that is impossible. And first of all, it's nice to see the president say, not the quiet part, but the unconstitutional part out loud. And here's what I would say to him. You know, one of his third-rate DOJ lawyers should really pull him aside and say, listen, Mr. President, I understand that your concept of notice and opportunity to be heard is probably born of your criminal prosecution in New York, which was a full-blown, very involved, soup-to-nuts prosecution. That can take months, if not years. That's not what we're talking about when it comes to a deportation hearing where somebody's entitled to notice and opportunity to be heard. That can be done quickly, efficiently, literally in a matter of days or weeks. It's not a full-blown trial, Mr. President, so we understand your confusion, but actually the system is up to handling the constitutionally required process that these immigrants must enjoy before they are deported.
Well, Glenn, let me ask you this, because we've already seen folks who've been deported, and so for those who have been deported, where do they stand in all of this? Because now some atmospheric precedent is taking place, and yet they don't get to enjoy it because they've already been sent out of the country without the same benefits that are being conferred to these other plaintiffs.
Yeah, Brian, that's the perfect question, and for once, I think I have an almost perfect answer, because the Supreme Court has already ruled in the Abrego Garcia case. What happened to Mr. Garcia? He was deported wrongfully, unlawfully, unconstitutionally, and in violation of a court order prohibiting the government from deporting him specifically to El Salvador. So what happens? Well, we know what happens because both a federal trial court judge and the Supreme Court ordered that Abrego Garcia must be brought back to the United States, and the executive branch, the Trump administration, must facilitate his return, and it must treat his case the way it should have been treated in the first instance. That's a pronouncement from the Supreme Court. So let's apply that to the question you just asked. I would say absolutely the Supreme Court has spoken. These immigrants who were wrongfully deported in the first instance all should, they haven't been ordered yet, but they should be returned to the United States and have their due process rights honored the way that it should have been done in the first instance.
Glenn, how unorthodox do you think it is that the judge in this case was so quick to shut down the Trump administration? And to what extent do you think that was born out of the Trump administration's obstinance in all of these, or outright defiance in all of these court cases? Like, do you think that these judges are starting to see the way in which the administration is comporting itself in other cases and kind of accounting for that before they give them all of this leeway, before they give them all of this benefit of the doubt?
Brian, I think the snowball of justice, so to speak, is gaining speed, is gaining mass, and is gaining momentum because we are seeing federal court judge after federal court judge, basically announce in substance with their rulings, we are done with Donald Trump's, constitutional gamesmanship. We are going to step up, we're going to stand strong, and we're going to make sure that, the constitutional rights of everybody, immigrants and citizens alike, are honored, are not run roughshod over by the Trump administration. So I think the way we see them ruling now, promptly and pretty sternly, pretty unforgivingly, when it comes to the constitutional rights that the Trump administration is trying to violate, I think we're going to see more of it, not less of it. I think momentum is gaining for the judiciary to hold the Trump administration accountable early and often. And really, the only remaining question is, does the Trump administration comply with court orders as our constitutional construct of government requires? And, if they choose to defy court orders, that is Donald Trump in a very real sense trying to bring an end to our constitutional construct of government, checks and balances, and co-equal branches of government. And, then it's anybody's guess as to how we move forward as a healthy, indeed a viable democracy, if that is the path Donald Trump chooses.
Well, look, it's clear that the administration wanted to deport these people after 24 hours. That was what they offered in this case. And so, would it lend itself to reason here that we'll know if the Trump administration opts to either comply or refuses to comply if they do indeed ship off at least the plaintiff at question in this particular case after a day or so.
Yeah.
Or really anything under 21 days.
We will know, Brian, if they choose to defy this 21-day order in this court, which covers only a handful of the Venezuelan immigrants who are being detained pending deportation. They're being detained in multiple facilities around the country. But, we did get some hint of the Trump administration flinching previously in recent days rather than openly defying court orders. You may have seen the reporting as these cases were being litigated on an emergency basis Friday night into Saturday morning, and we got that dramatic 1 a.m. ruling, edict handed down by the Supreme Court saying, stop all deportations. What we know, based on some reporting, as bolstered by some videotape footage, is they had put a bunch of Venezuelan immigrants who were being held at a detention facility in Texas, the Blue Bonnet detention facility, put them all in buses, headed out to the Abilene airport as these issues were being litigated. And what did we come to learn? They went out to the Abilene airport, they passed the airport exit, they made a U-turn, they came all the way back, and they re-delivered those immigrants to their jail cells in the Blue Bonnet Detention Center. It looks like they flinched because they were about to be caught red-handed, the reasonable inference supports, defying court orders if they actually deported those immigrants. So I think that's an indication we can take some comfort from that data point that maybe the Trump administration is not, really intent on openly defying court orders. At least we can hope that's the case.
Yeah, I mean, the bizarre thing is that this is already an issue on which Trump polls the best, and yet he is digging in on the one thing where he actually polls the worst, which is depriving people of due process. It's not like if he just carried out the process as it's intended to be carried out, which is to give everybody this very brief trial. This one, you yourself had noted that it only takes a day or so to get these things through the correct process, and then he can carry out his plan. But he is actually finding a way to make his most politically popular agenda item one of his most politically unpopular agenda items by virtue of depriving people of their due process in the United States of America. This is a constitutional right that's afforded to everybody who is here. And so, leave it to Trump to kind of screw himself over in that respect. But look, we will, of course, stay on top of this issue. This is very fast moving, as are all of these immigration issues. So for those who are watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. It's also the best way to support independent media more broadly. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.